I am Ruby Wake, and today I want to discuss probate. It's a big misconception as to what is probate, and a lot of clients come to me and say, oh, I'm going to avoid probate. I have nothing to worry about because I have a will. That's furthest from the truth. It's the complete opposite. In fact, probate means the court verification of a will, the court approval of a will. Probate means will. So if you have a will, you will go through probate unless you do take steps to avoid it. I'm going to go into why you want to avoid probate in another video, but I just wanted to be clear and just make this little sort of video that if you have a will, and only a will, you will be going through probate unless you take additional steps. Probate is the process where we submit your will, a petition for probate, and a death certificate to the county in which you resided at the time of your death, or resided in at the time of your death. And then we sort of sit around and wait for the court to review the will, review the application, and if all goes well, they will issue what's known as letters of administration. I'm assuming at this point that no one has contested the will up until this point. So that's why I said, if all goes well, the judge will issue what's known as a letters of administration and sign an order appointing you as personal representative. Personal representative is also known as an executor in some jurisdictions or an administrator in some jurisdictions. Personal representative, executor, administrator, they all mean the same thing. And what they mean is the person who's in charge of your estate. So once that person gets appointed is where the fun begins here in Florida. Florida takes the position that if you owe someone money at the time of your death, you should pay them. And if you couldn't pay them while you were still alive, your estate should pay them. And that's any assets that are named, that are in your name at the time of your death, that do not have a beneficiary designation, will go through the whole probate process, will be pulled into probate. So if you have a bank account in the name of John Smith and a house in John Smith's name, the house and the bank account will need to get probated. So once the letters of administration are signed by the judge, we will go ahead and enter this concept of notice to creditors. So Florida, like I said, takes the position that if you owe someone money, you have to pay them back, or your estate does. So they also recognize the fact that not everyone is very honest as to what debts they owed. So if you have any known creditors, that means your personal representative received the American Express bill, so they know that there's an American Express bill out there, we have to send them something known as notice to creditors. That gives them notice that, hey, this person died, he owes you money, and they just filed a probate petition, so you better file a claim now. In addition to that, the state of Florida makes us do something known as publication. So we have to publish a notice to creditors in a local newspaper saying that you passed away. So that's just putting sort of the public in general on notice that you passed away and we're attempting to probate and collect your assets. Now, a lot of my clients will sit here and luckily have the privilege of saying, well, Ruby, I don't have debt and I don't have any creditor claims. So I'm not concerned about this whole creditor period. The problem is that we don't know what we're going to owe when we die. And most of us, in my experience, most estates are not depleted by those small credit card bills. They're depleted by the last hospital bills and ambulance bills and that 2-week stay that you were in the hospital and doctor bills. Those are the creditor claims that really, really impact an estate. So you will often hear people say that you have to avoid probate because not only are you opening and exposing your estate to all of these creditor claims, they also tend to be pretty expensive and lengthy and cumbersome. So remember that client, John Smith, he had a bank account and a house that are now stuck in probate. What I didn't mention is that he also had a mortgage on that house. Who's going to pay for the mortgage while we're going through probate? Can your children afford to pay for the mortgage? If they have their own mortgage that they have to pay for, who's going to pay for the general upkeep of this house while we're going through this probate process? The probate process usually takes about a year to a year and a half, depending on the complexity of the estate and exactly what is going on. So during that time, your children are sort of on hold and waiting for their inheritance. To some families, it might not be as impactful as others, but to families who have perhaps minor children who are reliant and dependent on that inheritance and need a place to stay or need, to be provided for in general, what's going to happen then? So you will often hear clients here in the state of Florida say we have to avoid probate. Some states probate is not a big deal. I come from New York. New York, no one's worried about probate. We have different considerations that we take into account for estate planning. But here in the state of Florida, it is a pretty cumbersome probate process. It can take, at a bare minimum, at least 4 months because of the creditor period, and it never ever takes just 4 months. It's always at least a year to a year and a half. So if you are worried about probate, or if you're going through probate right now, it's really important that you do consult with an experienced probate attorney who can assist you and guide you through the process. Because remember, as a personal representative, you have a fiduciary duty to the beneficiaries of that estate. So it's not as simple as just collecting the money and paying it out. There are so many different things that you have to take into account. So it's really important that you consult with an experienced probate attorney who can guide you and provide you with the proper steps to protect you and protect the beneficiary.